So what I'm going to do is give essentially an overview of my recent book, of this Bostock case, what went behind it, and then after that we have that background information, dig into the chapter that went along with tonight's readings, and try to not necessarily explore all the ins and outs of what happened, but I want to use that chapter as a basis for understanding different ways of doing political science, or more qualitative ways of understanding these issues, which is the kind of work that I do. It's not as much tied to data sets and public opinion, which is a very important thing and central to our discipline. But there are a lot of other ways of thinking about how we create knowledge in the discipline that I think that I hope I can try to show you through understanding the sources that I used for this book, and that this chapter in particular, which has more archival work and focus on documents and legal documents and all kinds of things. So before we get into that methodological issue, let's see if I can share my desktop. Can you see that PowerPoint?
Yeah, and now it's in full screen mode.
Okay.
Take it up the whole screen. It looks good.
Okay. All right. So we should probably start with the text of the statute we're talking about. And what's interesting about this issue in this case is that it wasn't about the Constitution per se. It was about a statute, a very famous statute, the Civil Rights Act of 1964. And you can read it if you want to. I won't read the whole thing, but it was at least the Title VII is focused on employment discrimination, and it used about in the middle of the code. It uses the words race, color, religion, sex, or national origin, and it's illegal to limit, segregate, or classify employees. They use sexist language. This is the 1960s, and so at the very time they're putting the word sex in the statute, they're still using sexist language. But the question then became, what is included in the word sex in particular? And because the Civil Rights Act of 1964 was, as we all know, and it's pretty standard knowledge, was mostly about the Civil Rights Act and racial discrimination. But the word sex was added as a part of the conversation when Congress began debating this legislation in 1963 and 1964. The amendment to have the word sex was put in by a Democrat, Southern Democrat, I think it was from Virginia, who was a segregationist or racist, but he was also, interestingly, a supporter of women's rights, or at least white women's rights. He had supported the Equal Rights Amendment. And some people theorize that, and I think a standard historical narrative or public narrative is that this amendment, adding the word sex, was put in to sabotage the larger project. And there is some truth to that. Certainly, Smith would have been more than happy to see the Civil Rights Act fail. But Smith was also connected to, as I said, some feminist activists, perhaps on the more conservative side of things, but still thought that sex discrimination was, to some limited degree, a problem. And in particular, not just Smith, but a lot of feminist activists at the time saw this amendment as a crucial inclusion and a crucial part of the evolving women's rights movement that was forming in the 1960s. So, a lot of feminist scholars have pushed back on this narrative that it was a poison pill that was simply put in to scuttle the bill. I think the history is a lot more complex, and it is tied a lot more to decades of activism in the feminist movement to try to add protections in federal law on the basis of sex. Now, what is true is that there is no discussion, and there was no discussion of LGBTQ rights during that debate. And this becomes important legally because there's a theory of statutory interpretation that is fairly prominent, and it's called legislative intent or legislative history. So if we want to try to understand what the word sex in that statute means, one of the things we could do is say, well, what were they trying to do at the time? Look at floor debates, look at committee reports. And if we see them say we were trying to also include trans folks and queer folks, then maybe you've got a case. But if not, then you're out of luck, and sex does not include LGBTQ rights. So that would be a legislative intent approach. But in the end, the Supreme Court didn't take that approach. They took what's called a textualist approach. But there was a very important figure, and part of this is just interesting history, but important history. Pauli Murray, a very important legal thinker and political activist in the 1960s, tied to the Black Civil Rights Movement, tied to the feminist movement. Murray wrote a lot of articles and legal briefs arguing for women's equality in particular. Murray themselves was a closeted queer person, gender nonconforming. We might actually consider, a lot of scholars consider Pauli Murray trans today if they were around today. And Murray thought very intersectionally before intersectional analysis was a thing, and made connections between different forms of discrimination and oppression, and certainly lived a life that was multifaceted and based on multiple identities, and was very influential in getting Congress to keep the word sex in this amendment and keep that concept of sex-based discrimination in the Civil Rights Act of 1964, mostly behind the scenes, but very influentially behind the scenes. But no one really thought that there was an intent beyond perhaps the thoughts of Pauli Murray to include queer and trans people in these protections. And yet, just a few years after the law was enacted, trans and queer individuals began to bring cases under the statute because they were fired for being trans or for being queer, gay, lesbian, bisexual. But because of this legislative intent approach, which was very prominent during the 1970s, judges said, hey, we looked at the record, they didn't talk about gender nonconformity, they didn't talk about trans people or queer people, so they talked about cis women, to use terms, they talked about women, they talked about racial discrimination, they didn't really talk about anything else, so they talked about religion, and it's there as well, but not gender identity and sexual orientation. It's not in the statute. It's not in the intent of the statute. It's not there. You're out of luck. You can't sue on the basis of this statute. And that was the law for decades and decades and decades. The idea that the word sex in the statute did not include gender identity and sexual orientation. But there were two very important decisions that shifted the legal ground that would eventually be created in Bostock. That would eventually create the legal setting by which the Supreme Court would eventually argue in 2020 that sexual orientation and gender identity were in fact part of the word sex in the Civil Rights Act. And one was Pricewaterhouse versus Hopkins. So the subtitle of the book before Bostock is The Accidental LGBTQ Precedent of Pricewaterhouse versus Hopkins. That was in 1989. And then there was this case, 1998, on Kell versus Sundowner Offshore Services. So what were these two cases about? Well, Hopkins is interesting because it wasn't at all an LGBTQ rights case. It was a case brought by a straight cisgender woman, Ann Hopkins, who was fired from Pricewaterhouse, the accounting firm, because she was perceived as being too masculine. She was denied a partnership. Her partner said things like she should go to charm school. She used rough language. She didn't have a sufficiently feminine presentation in her dress and clothing. And those things were in her personnel record when she went up for partnership. And she was able to prove through this litigation that the stereotypes her colleagues had about her gender role or gender norms was a form of discrimination under Title VII. The term the courts began to use was sex stereotyping. When someone's gender presentation isn't consistent with someone's idea of what that gender should be. So if someone who transgresses the gender binary and is penalized for doing that in the workplace, the court ruled that that is a form of sex discrimination, actionable under Title VII. So it was technically a plurality opinion, but there were probably 6 votes on this question of sex stereotyping. So it was a very important gender rights case, and it was a new theory, and it was being developed on the court along with sexual harassment. So 2 or 3 years before this case, the court ratified the idea of sexual harassment as also actionable under Title VII. So in the 80s, the Supreme Court was expanding the types of discrimination that were prohibited by the Civil Rights Act, including sexual harassment, and then now, in this case, sex stereotyping. But it wasn't immediately clear for a wide variety of reasons, and the chapter that you looked at from the book talks about this. To progressive lawyers and trans rights lawyers, how this case would apply or should it apply. Some people had some idea that it might fit, but there had been such strong opposition and such strong resistance to reading the Civil Rights Act to include trans rights for decades because of this legislative intent approach that most activists by the 1990s said that there need to be other avenues to try to get at trans discrimination in the workplace other than the Civil Rights Act. About 10 years later, another case, which was about sexual harassment, in this case, same gender sexual harassment, led to a second crucial part of this evolution. The first was the development of sex stereotyping theory, or jurisprudence from the court. And the second one relates back to this issue of legislative intent versus other approaches. And Antonin Scalia was the author of this unanimous opinion in 1998. And it was somewhat unusual for Scalia to be the author of this opinion because he in general had a very negative LGBTQ rights voting record on the court, pretty conservative, voted against marriage equality, voted against legalizing eliminating sodomy laws, all kinds of things. But he had a particular idiosyncratic, perhaps we could say, understanding of statutory interpretation, not constitutional interpretation, statutory interpretation, how judges interpret statutes. And in particular, he hated legislative intent because he thought if judges rely on legislative intent, they will cook the books too much. They will be far too prone to interpret the legislative record in a skewed way because there's so many different things they can look at, different floor statements, different debates, all kinds of things in the legislative record. Legislators often cook the books in a certain direction to try to get judges to interpret statutes in a certain way. So to try to prevent that approach that opens the door toward judicial freelancing, Scalia wanted judges to stick to the text. And in this case, because, as I mentioned, the court had already said that sexual harassment was actionable under Title VII, and then that was generally in the context of opposite sex sexual harassment, men harassing women for the most part in the workplace. This had to do with same-sex sexual harassment. Joseph Anquel was a roustabout on a offshore oil rig in the Gulf of Mexico. He was not gay, he was straight, but for some reason his employees perceived him to be gay or taunted him for being gay, and there was all kinds of verbal harassment, even a physical harassment, quasi-sexual assault in a communal shower. At one point, this guy really went through a lot of horrible stuff, and he said this should be illegal as well. I quit. He quit his job, he said, but it was because of this tremendous pressure. And if that was a woman, he clearly would have been able to go to court and sue. So he went, and ultimately the Supreme Court said, well, we think Joseph Anquel is right, because even though the legislators in 1964 weren't thinking about same-sex sexual harassment, the word sex includes the concept. Because what Scalia and his fellow justices were really trying to do is get rid of any vestige of legislative intent approaches and focusing more on the words in the page as opposed to what legislators intended. And that was a breakthrough, because that means that now we can start talking about how the word sex might have a more modern definition, divorced from what the intent was of the statute in 1964. And so he wrote, I think it's worth reading this out and contemplating it. So we see no justification in the statutory language or our precedents for a categorical rule excluding same-sex harassment claims from the coverage of Title VII. As some courts have observed, male-on-male sexual harassment in the workplace was assuredly not the principal evil Congress was concerned with when it enacted Title VII, but statutory prohibitions often go beyond the principal evil to cover reasonably comparable evils, and it is ultimately the provisions of our laws rather than the principal concerns of our legislators by which we are governed. So this severing of the interpretation of Title VII from legislative intent was a big turning point, even though Scalia certainly wasn't trying to do that. He was simply making a point about statutory interpretation. And shortly after this decision is when activists and scholars finally began to realize that this combination of cases, Price Waterhouse and Onkale, could be a very potent combination for expanding transgender rights through the courts. Not in political campaigns, not in grassroots activism, but in litigation. And some of these activists, some of whom were in mainstream activist organizations like Lambda Legal, National Center for Lesbian Rights, these institutions had developed pretty good litigation records by the 2000s. They began to say, well, we need to focus more on transgender rights, and we have a good path to perhaps do so. And they started not by focusing on the Civil Rights Act, but they looked at other statutes, federal statutes, that had the word sex. And they tried to argue that these two cases, Pricewaterhouse and Onkale, compel judges to think about the word sex in new and more expansive ways, with the goal, hopefully, that those would then be precedents to use to then get judges to apply that reasoning to Title VII itself. And so there were some successes around 2000 of activists using this strategy in other federal laws, about consumer credit and inmates. And then eventually in 2004, an appellate court of the Seventh Circuit found that actually you could use sex stereotyping theory as a basis for protecting trans folks who face discrimination in the workplace. And so this created a certain momentum in the federal courts, this 1-2 punch of Bostock and Onkale, that began to develop, particularly in the context of transgender rights. This was a harder lift for sexual orientation because of a wide variety of reasons, but part of it had to do with the text itself. A lot of judges said, well, we can buy how gender identity might be tied to the word sex, but we're not so sure how sexual orientation as an identity is tied to sex, even though both involve sex and sexual intimacy in the latter case. A lot of judges said, we're not going to bootstrap protections on the basis of sexual orientation onto this law, largely because there were pretty advanced congressional debates about including sexual orientation into the civil rights framework. And they said the political process is already responding to it, one, and we're not sure that it's quite the same kind of fit that gender identity might be, particularly given the sex stereotyping theory from Price Waterhouse. And in this trend, generally Democratic appointees, federal judges appointed by Democrats, were more supportive of using this combination of cases to expand trans rights. Republican appointees were more divided. And this was certainly the case in Bostock itself, because all the liberals voted in favor of inclusion of gender identity and sexual orientation. The conservatives were more split. So ideology did play a role in this policy innovation, and more moderate Republican judges and Democrats were the primary driving forces behind this change in the 2010s up to before 2020. And the activist community saw this momentum, and they thought that they had a lot of good law on their side, and they kept bringing test cases, and they started bringing test cases on the basis of sexual orientation, not just gender identity. But they had been counting on the vote of Anthony Kennedy, who retired in 2018. And they thought, well, he had been a very pro-LGBTQ rights justice. He voted in favor of marriage equality, wrote the famous marriage equality decisions in Lawrence versus Texas. But he left the court, and they were stuck with Kavanaugh. And Kavanaugh ended up voting against them in Bostock in 2020. So they changed tactics, and they said, we can't focus on a person anymore, an ideology. We have to try to focus back in on that Scalia argument about textualism. And their new target was Justice Gorsuch, who was newer to the court. And this is a great quote about their strategy from one of the leading architects of the strategy, Chase Strangio, who works for the ACLU. And they realized after Kennedy left the court, Gorsuch might be persuaded by a Scalia-like textualist argument that doesn't emphasize legislative intent, but tries to focus on the words on the page or how judges might properly view them. A law professor wrote an article that gave them some inspiration for this approach. But they had to be very tactical and careful about how they did this. It wasn't a guarantee. In the end, it worked pretty well, but they had to be very careful and strategic. And I think this quote also tells us how careful and strategic movement lawyers are and can be. They don't just bring cases thoughtlessly and because they think something has been unjust or something. They are meticulous about the framing of the arguments, the kinds of judges and justices they're targeting, and they really narrowly tailor things to get the best results. So all these cases were coming to the court. At the same time, there were some gender identity-based cases, some sexual orientation-based cases. By 2020, the Supreme Court put them all into one case. There was one transgender plaintiff, Amy Stevens, and two gay men's discrimination cases, Zarda and Bostock, who were all put together, and they heard the arguments side by side, whether or not gender identity and sexual orientation were included in the word sex. And what's interesting is that even though, as I've pointed out, the legal arguments in favor of trans inclusion were stronger in terms of precedents and how things have been developing, the justices themselves, especially during the oral arguments, really struggled with transgender rights and the idea of transgender rights. And they asked a lot about bathrooms, and that was one of the dominant issues around 2020. And also true in their deliberations, a lot of journalist accounts have showed they really struggle with the idea, well, if we find in favor of trans rights, what are the implications for the workplace? But on this issue of textualism, during the oral arguments, there was a snippet of hope for activists, LGBTQ rights activists, in making this argument that the text of the statute includes gender identity and sexual orientation. At one point, Gorsuch says, "I'm with you on the textual evidence. It's close." Okay, the judge finds it very close. In the end, essentially, Gorsuch adopted the Scalia idea that we could, even though this wasn't intended, it's there, it's included, and we're going to rule that discrimination on the basis of sexual orientation and gender identity are part of the Civil Rights Act. Again, this was surprising for some, for many folks, including the fact that Roberts went along with Gorsuch as well, the more conservative Chief Justice. Now, why is this important beyond the employment context, and why might this also be relevant for discussions about gender-affirming care and trans athletes, all kinds of school settings? The word sex, as I've explored already, appears a lot in different federal statutes. And courts generally interpret those statutes and the words in those statutes in similar ways and will cite from one area of jurisdiction to another. So for instance, even though these were Title VII cases from the Civil Rights Act, the reasoning might also apply to Title IX, the educational amendments in 1972 about sexual discrimination, sex-based discrimination in education. So there are a lot of immediate spillover potentials for activists to use this case in other contexts where federal law talks about sex discrimination. The court itself in Bostock Civil were not yet dealing with issues like, can there be religious objections to employment discrimination based on sexual orientation and gender identity? They left the bathroom question open for future resolution. That has in some ways opened the door for conservatives to start arguing that those issues should go in a more conservative direction in the courts. But I think one of the reasons why this was not as surprising as it might otherwise have been for folks is that public opinion is strongly in favor of non-discrimination in employment on the basis of gender identity and sexual orientation. So the court wasn't necessarily doing anything radical in terms of public opinion by saying, we think queer and trans people are included in the Civil Rights Act of 1964. there certainly wouldn't be I think there wasn't going to be a public backlash to that opinion directly. They might have been more protected from the public in that sense, unlike something like Dobbs overturning Roe, which has been proven to be very unpopular in public opinion and in politics. So this was obviously a pretty big victory for progressives and for liberals, for the LGBTQ rights movement. But I think it's also part of the wave of conservative legislation that has promulgated itself in states in the past couple of years since 2020. Part of this is a strategy to try to use these policy areas to have courts revisit Bostock and the whole logic of Bostock and textualism that was promulgated in that decision. The blog post that I published last year tries to bring this up to date a little bit, although things are changing rapidly. But what I found is that the same kind of pattern before Bostock is still in place, where almost always Democrats are applying Bostock in broad and expansive ways, and some Republicans are. But some of the most conservative judges, particularly Trump judges, are aggressively trying to argue around Bostock or using other areas of the law to try to limit trans rights and to uphold a lot of these restrictions on trans rights that we've been seeing in the past couple of years. Some recent development is so the PowerPoint says some judges are using Dobbs, the abortion rights case. In fact, an 11th Circuit Court of Appeals decision from just a few weeks ago cited Dobbs for the proposition that there is no transgender right to healthcare, to equal healthcare, and that laws limiting trans youth and trans adults from access to healthcare can be allowed from states. The argument was that even though there's a right, and in the context of youth in particular, the right of parents to control their children's healthcare decisions and healthcare destinies, the court said, well, Dobbs talked about rights being firmly rooted in tradition, and because transgender rights are new and trans parents are more recent, that there is not a historic right to the parents of transgender youth having some freedom to work with doctors to forge a healthcare path for their children. So here, these conservative judges are using the abortion decision, the anti-abortion decision, and the restriction of the right to privacy to restrict transgender rights. That's a very ideological thing to do. I think increasingly we're going to see the court split on this, and ultimately I think the Supreme Court will have to retake some of these cases and revisit the question of whether or not Dobbs really, or whether or not Bostock really is a bulwark against this wave of litigation, or if it was just a blip on the radar screen. So that's a big overview of how we got to this rather remarkable opinion, and what's happened since then to some degree. So now I want to stop talking and turn the floor